Table of contents. Definition and purpose. Legal basis, the manner of opening. Why it matters. Postponement, public access, and the abstract of bids as read. Documents submitted by the bidder, the complete list. The Omnibus sworn statement, in full. What the back checks and records. Step-by-step procedure. Rejection, late bids, and sealing rules. Electronic and scanned submission, special rules. Goods, infrastructure, and consulting services, compared. Applicability by mode of procurement. Virtual and electronic conduct. The top 20 reasons a bidder failed to pass. Documents checklist, audit observations, and closing. Next slide. What this reference covers. This reference is a single, comprehensive treatment of bid opening. What it is, exactly how the manner of opening changes depending on the award criterion, the complete. Itemized list of documents a bidder must submit and the back must open and check, how this differs across goods, infrastructure projects, and consulting services. How it applies across different modes of procurement and to force account projects, how it may be conducted virtually. And the 20 most common reasons a bid fails to pass at this stage. It follows the same structure as the companion guides on the pre-procurement conference and the pre-bid conference. Every citation has been checked directly against the full, official text of the implementing rules and regulations of Republic Act No. 12,009. Next slide. Section 1. Definition and purpose. The public, irreversible moment when sealed bids become documents the back and the public may examine. Next slide. Section 1.1. Definition. Bid opening is the formal, public act of unsealing the bid envelopes submitted by prospective bidders, conducted immediately after the deadline for submission and receipt of bids. At the time, date, and place already fixed in the bidding documents. It is the point at which a bid stops being a private, sealed submission and becomes a document the BAC, and, in significant part, the public, may examine. It is also irreversible. Once a bid is opened, it cannot be withdrawn or modified except under the narrow circumstances the IRR allows before the deadline itself. Next slide. Section 1.2. Where this sits in the procurement sequence. Bid opening happens immediately after the bid submission deadline, which itself follows the invitation to bid publication and, where applicable, the pre-bid conference discussed in the companion guide. It happens immediately before preliminary examination and bid evaluation. Because of this position in the sequence, bid opening is where two earlier bodies of work, the two envelope submission rules under Section 54, and the eligibility documents described under Section 52, actually surface and become visible for the first time. Next slide. Section 2. Legal basis, the manner of opening. How the sequence of opening the two envelopes changes depending on the award criterion adopted. This is an important requirement to check during a compliance review. Next slide. Section 2.1. Legal basis, the manner of opening, in full. Legal basis, IRR of RA number 12,009, Section 58. The manner of opening of the bids for goods and infrastructure projects shall depend on the award criterion to be adopted, as follows. A. For LCRB. The back shall open the technical and financial proposals on the same day, and B. For MEARB or MARB. Only the technical proposals shall be opened while the financial proposals shall remain unopened and be secured by the back until the specified time of their opening. Only the financial proposals of the bidders who have met the minimum technical score for MEARB or the highest technical score for MARB shall be opened. Next slide. Section 2.2. Same day versus staggered opening. Award criterion, how the envelopes are opened. LCRB, lowest calculated responsive bid, both technical and financial envelopes opened on the same day, for every bidder. MEARB, most economically advantageous responsive bid, only technical envelopes opened first. Financial envelopes remain sealed and secured until technical scoring is complete. Then opened only for bidders meeting the minimum technical score. MARB, most advantageous responsive bid, same staggered approach. Financial envelope opened only for the bidder achieving the highest technical score. Next slide. Section 2.3. Why this sequencing rule exists. The staggered opening for MEARB and MARB exists to protect the integrity of the technical evaluation, if the financial envelope were opened at the same time as the technical one. Evaluators scoring the technical merit of a proposal could be consciously or unconsciously influenced by knowing the bidder's price, undermining the independence the quality scoring is supposed to have. This is precisely why the award criterion must be finally settled at the pre-procurement conference, discussed in the companion guide, well before bid opening. The BAC needs to know, in advance, which of these two opening sequences actually applies to this specific procurement. Next slide. Section 2 Observation. Common Audit Observation. Issue 1. Second envelope opened prematurely under MEARB or MARB. The BAC opened the financial envelopes of all bidders on the same day as the technical envelopes despite using MEARB or MARB as the award criterion. Contrary to the sequential opening the law requires for those criteria. Legal, regulatory basis, IRR of RA number 12,009, Section 58, B, next slide. Section 3. Why it matters. What this single, public moment actually protects, for the government and for every competing bidder. Next slide. Section 3.1. The point where confidentiality converts into transparency. Every earlier stage in the procurement cycle, from the pre-procurement conference through the final drafting of the bidding documents, operates under a strict confidentiality regime under Section 48 of the IRR. Bid opening is the precise, single moment that regime deliberately ends, and a new regime of public transparency begins. Getting the sequencing of this moment wrong, opening the wrong envelope too early, disclosing a password ahead of time, or allowing informal early access, does not just violate a procedural rule, it collapses the very distinction between the confidential and public phases of the procurement the whole legal architecture depends on. Next slide. Section 3.2. It is the foundation everything afterward depends on. Preliminary examinations pass or fail determination, discussed in an upcoming section, is applied to whatever was actually, validly opened at this stage. An error here, an envelope opened out of sequence, a late bid wrongly accepted, a properly sealed bid wrongly rejected, propagates forward into every subsequent stage of the procurement. This is why bid opening, despite appearing procedurally simple on its face, carries outsized legal weight. It is the single narrowest gate through which every later stage of the procurement, evaluation, post-qualification, and eventual award must pass. Next slide. Section 3.3. It protects bidders from each other, not just from the government. Public bid opening is as much a protection between competing bidders as it is a check on the procuring entity. A bidder who watches its competitor's bid price read aloud, in public, on the same day its own bid is opened, has direct, immediate assurance that no one had a chance to adjust their own price after seeing someone else's. This mutual protection disappears the moment any bid is opened outside the public, recorded process this reference describes. Which is precisely why even a single instance of premature or informal opening compromises the entire competitive field, not just the specific bid involved. Next slide. Section 4. Postponement, public access, and the abstract of bids as read. What happens when opening cannot proceed as scheduled, and what becomes public once it does? Next slide. Section 4.1. Legal basis, postponement. Legal basis, IRR of RA number 12,009, Section 58. In case the bids cannot be opened as scheduled due to justifiable reasons, the BAC shall secure the bids submitted and reschedule the opening of bids on the next working day or at the soonest possible time through the issuance of a notice of postponement to be posted on the PhilGEP's website and the website of the procuring entity concerned. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Section 4.1. What counts as a justifiable reason, and what the BAC must do meanwhile. The IRR does not enumerate an exhaustive list of justifiable reasons, but the structure of the provision makes clear that postponement is meant to be the exception, not routine practice, and it is conditioned on the BAC actively securing the submitted bids in the interim, not simply leaving them unattended. The notice of postponement is not optional paperwork, it is the mechanism that keeps every prospective bidder, including those who did not attend the originally scheduled opening, equally informed of the new date, since it must be posted on both the PhilGEP's website and the procuring entity's own website. Next slide. Section 4.2. Legal basis, attendance, integrity, and public access. Legal basis, IRR of RA number 12,009, Section 58. The bidders or their duly authorized representatives may attend the opening of bids. The BAC shall ensure the integrity, security, and confidentiality of all submitted bids. The abstract of bids as read, and the minutes of the bid opening shall be made available to the public upon written request and payment of a specified fee to recover the cost of materials. This rule is often a point of focus when verifying compliance with the law. Next slide. Section 4.2. Attendance is optional, but documentation is not. Bidder attendance at the actual opening is optional, exactly as it is at the pre-bid conference. What is never optional is the BAC's own duty to ensure the integrity, security, and confidentiality of every submitted bid right up until the moment of opening, and to prepare an abstract of bids as read, and minutes, that any member of the public may request afterward, upon payment of only a materials cost fee. This is the origin of the phrase bid as read, central to the discussion of bid evaluation in the companion guide to this series. It is literally the figure read aloud and recorded at this exact moment, before any arithmetic correction is later applied. Next slide. Section 4 Observation. Common Audit Observation. Issue 2. Bid opening postponed without a proper notice of postponement. The scheduled bid opening did not proceed as planned, but no notice of postponement was issued and posted on PhilGEP's and the procuring entity's website, leaving bidders uninformed of the new schedule. Legal, regulatory basis, IRR of RA number 12,009, Section 58. Next slide. Section 4 Observation. Common Audit Observation. Issue 3. No abstract of bids as read prepared or made available. The BAC failed to prepare, or refused to make available upon a proper written request and fee payment, the abstract of bids as read from the bid opening. Legal, regulatory basis, IRR of RA number 12,009, Section 58. Next slide. Section 5. Documents submitted by the bidder, the complete list. Exactly what goes into each envelope, itemized in full, for goods, infrastructure projects, and consulting services. Next slide. Section 5.1. Legal basis, the two-envelope rule. Legal basis, IRR of RA number 12,009, Section 54. 1. Bidders shall submit their bids through their respective duly authorized representatives using the forms specified in the bidding documents in two separate sealed bid envelopes, or in appropriate documents and file format for electronic bid submission, which shall be submitted simultaneously. The first shall contain the technical component of the bid, including the eligibility requirements under Section 52 of this IRR. And the second shall contain the financial component of the bid. Next slide. Section 5.2. Legal basis, Envelope 1, for goods. Legal basis, IRR of RA number 12,009, Section 54. 2. The first bid envelope shall contain the following technical documents, at the least. 1. PhilGEP's Certificate of Registration, Platinum Membership. 2. Statement of all ongoing government and private contracts. 3. Statement of SLCC. 4. NFCC computation or committed line of credit. 5. JVA or the duly notarized statement. If applicable. 6. Bid security in the prescribed form, amount and validity period. 7. Technical specifications, which may include production or delivery schedule. manpower requirements, or after-sales service or parts, if applicable, 8, Omnibus sworn statement, and 9, for foreign bidders claiming eligibility by reason of reciprocity. A certification from the government confirming Filipinos are allowed to participate in their government procurement activities for the same item or product. Next slide. Section 5.2. Envelope 1 for goods, at a glance. Document. I. PhilGEP's Certificate of Registration, Platinum Membership. E. Statement of all ongoing government and private contracts. E. Statement of SLCC. IV. NFCC computation or committed line of credit. V. JVA or notarized statement of intent, if applicable. VI. Bid security, correct form, amount, and validity. VII. Technical specifications, production, delivery schedule, manpower, after sales. VII. Omnibus sworn statement. X. Foreign reciprocity certification, for foreign bidders claiming eligibility on that basis. Next slide. Section 5.3. Legal basis, envelope 1, for infrastructure projects. Legal basis, IRR of RA number 12,009, Section 54. 2. B. 1. PhilGEP's Certificate of Registration, Platinum Membership. 2. PCAB License and Registration, in case of JV. 3. Statement of all ongoing government and private contracts. 4. Statement of SLCC. 5. NFCC computation. 6. JVA, if applicable. 7. Bid security in the prescribed form. Amount and validity period. 8. Project requirements, which shall include 1. Organizational chart for the procurement project to be bid. 2. List of contractors' personnel to be assigned to the project with their complete qualifications and experience data. 3. List of contractors' major equipment units, supported by proof of ownership or certification of availability. And 4. Omnibus sworn statement. Next slide. Section 5.3. Envelope 1 for infrastructure projects, at a glance. Document. I. PhilGEP's Certificate of Registration, Platinum Membership. E. PCAB License and Registration, required in case of joint venture. E. Statement of all ongoing government and private contracts. IV. Statement of SLCC. V. NFCC computation. VI. JVA, if applicable. VII. Bid security, correct form, amount, and validity. VII-1. Organizational chart for the project. VII-2. List of personnel, project manager, engineers, materials engineers, foreman, with qualifications. VII-3. List of major equipment, owned, leased, purchase agreement, with proof of availability. VII-4. Omnibus sworn statement. Next slide. Section 5.4. Legal basis, envelope 1, for consulting services. Legal basis, IRR of RA number 12,009, Section 54. 2. C. 1. The bid security in the prescribed form, amount, and validity period. 2. Organizational chart for the procurement project to be bid. 3. List of completed and ongoing projects. 4. Approach, work plan, and schedule, provided that for architectural design. Submission of architectural plans and designs shall not be required during the consultant's selection process. 5. List of key personnel to be assigned to the project, with their complete qualification and experience data. 6. Omnibus sworn statement. And 7. PhilGEP's Certificate of Registration, Platinum Membership. Next slide. Section 5.4. Envelope 1 for consulting services, at a glance. Document. I. Bid security, correct form, amount, and validity. E. Organizational chart for the project. E. List of completed and ongoing projects. IV. Approach, work plan, and schedule, architectural plans excused at this stage for architectural design engagements. V. List of key personnel with complete qualification and experience data. VI, Omnibus Sworn Statement. VII, Phil Gep's Certificate of Registration, Platinum Membership. Next slide. Section 5.5. Legal Basis, the second envelope. Legal Basis, IRR of RA number 12,009, Section 54. 4. The second bid envelope shall contain the financial documents as specified in the PBDs. Keep this requirement in mind, as it directly affects the validity of the transaction. Next slide. Section 5.5. Why envelope 2 is deliberately left more open-ended. Unlike the highly itemized first envelope, the second envelope's contents are simply as specified in the Philippine bidding documents. Since financial documents are naturally more standardized across project types, the bid form, the price schedule, and, for infrastructure projects specifically, the bill of quantities with unit prices filled in. This is precisely the material the discrepancy resolution rules discussed in the companion guide on bid evaluation apply to, since figures across the bid form, price schedule, and bill of quantities must all agree, and any conflict is resolved by the fixed rules in Section 61. 2. 3. Next slide. Section 6. The Omnibus Sworn Statement, in full. The one document common to every envelope 1, across every project type, worth its own complete treatment. Next slide. Section 6.1. Legal Basis, the 9 required declarations. Legal Basis, IRR of RA number 12,009, Section 54. 3. The Omnibus Sworn Statement shall contain the following. A. The signatory is the duly authorized representative. B. It is not blacklisted. C. Each of the documents submitted is an authentic copy of the original. D. It is authorizing the hope to verify all the documents submitted. E. It complies with the disclosure provisions under Sections 81 and 82. F. It complies with existing labor laws and standards. G. It complies with the responsibilities of a prospective or eligible bidder. H. It did not give or pay any commission to any representative of the government. And 1. In case of advance payment, failure to perform shall be sufficient grounds to constitute criminal liability. Next slide. Section 6.2. Why this one document deserves special attention at bid opening. The Omnibus Sworn Statement appears in every single envelope 1 list above, regardless of project type. Item 8, for goods. Item 8, 4, for infrastructure. Item 6. For consulting services, making it the single most universally required document at this stage. Because it is executed under oath, its absence, or any material falsity within it, carries consequences beyond ordinary procurement non-compliance. Falsification exposes the signatory to criminal liability under the revised Penal Code, independent of, and in addition to, any procurement-specific disqualification. Next slide. Section 6 Observation. Common Audit Observation. Issue 4. Documents opened did not match the required list for the project type. The BAC opened and accepted a first envelope missing one or more of the specific items required under Section 54. 2. For that project's category, goods, infrastructure, or consulting services, without rating the corresponding requirement as failed. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 2. A, B, or C. Next slide. Section 6 Observation. Common Audit Observation. Issue 5. Omnibus Sworn Statement missing one or more required declarations. The Omnibus Sworn Statement opened at bid opening did not contain all 9 declarations required under Section 54. 3. Yet was still accepted as compliant. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 3. Next slide. Section 7. What the BAC checks and records. The active, documented work the BAC performs at the moment of opening, beyond simply unsealing envelopes. Next slide. Section 7.1. Legal basis, late bids. Legal basis, IRR of RA number 12,009, Section 54. 6. Bids, including the eligibility requirements under Section 52. One of this IRR, submitted after the deadline, shall not be accepted by the BAC. The BAC shall record in the minutes of the meeting of the submission and opening of bids, the bidder's name, its representative, and the time the late bid was submitted. This is a key provision that procurement officers must apply correctly. Next slide. Section 7.1. A late bid is refused, but not ignored. The rule here has two parts working together. A late bid is never accepted, full stop, but its arrival is still formally recorded, the bidder's name, its representative, and the exact time of the late submission. This creates a permanent, auditable record of exactly how close, or how far, a rejected bidder actually came. This record also protects the BAC itself, since a documented, time-stamped log of a rejected late bid is direct evidence that the rejection was applied consistently and was not merely a discretionary or after-the-fact decision. Next slide. Section 7.2. Legal basis, notification of bidders whose bids were received by mail. Legal basis, IRR of RA number 12,009, Section 54. 7. To ensure transparency and accurate representation of the bid submission, the BAC Secretariat shall notify in writing all bidders whose bids it has received through mail at its PhilGEP's registered physical address or official email address. The notice shall be issued within 7 calendar days from the date of the bid opening. This detail is worth remembering when preparing supporting documents. Next slide. Section 7.2. A detail frequently missed. This specific obligation, notifying mailed-in bidders in writing within 7 calendar days of the bid opening, is often overlooked because it applies to a subset of bidders, those who submitted by mail rather than in person, but it is a genuine, distinct compliance requirement, not merely good practice. The 7-day clock runs from the date of bid opening, not from receipt of the mailed bid, meaning the BAC Secretariat must track this deadline actively rather than assuming it is satisfied simply because the bid itself arrived on time. Next slide. Section 7.3. Legal basis, the physical form of the bid itself. Legal basis, IRR of RA number 12,009, Section 54. 8. The original copy of the bid form shall be typewritten or written in ink and shall be signed by the bidder or its duly authorized representative. This provision is frequently checked during document review. Next slide. Section 7.3. A simple rule, frequently the source of disqualification. This provision is easy to underestimate precisely because it sounds like a formality, yet a bid form completed in pencil, or left unsigned, or signed by someone without demonstrated authority to do so, is a genuine, checkable defect the BAC must catch at this stage. Not something to be waived informally because the rest of the bid otherwise looks complete. Next slide. Section 7.4. What the BAC's minutes should capture. Item, why it matters. Every bidder's name and representative present establishes who actually participated in the public opening. The bid price as read, for every bidder, becomes the abstract of bids as read, the public record and audit baseline. Any late bid, with bidder name and exact time, documents a rejection decision was consistently and correctly applied. Any improperly sealed bid, and the bidder's acknowledgement, evidence the acceptance with acknowledgement rule under Section 54. 9 was properly followed. Which envelopes were opened, and under which award criterion sequence, confirms the correct LCRB or MEARB, MARB opening procedure was actually followed. Next slide. Section 7 Observation. Common Audit Observation. Issue 6, Late Bid Not Properly Logged. A bid arrived after the submission deadline and was correctly excluded from consideration, but the minutes failed to record the bidder's name, representative, or the exact time of the late submission. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 6 Next slide. Section 7 Observation. Common Audit Observation. Issue 7, Mailed in bidders not notified within 7 days. The BAC Secretariat failed to notify, in writing, bidders whose bids were received by mail, within the 7 calendar day window measured from the date of bid opening. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 7. Next slide. Section 8. Step-by-step procedure. The complete sequence, from immediately before the deadline through the finalized minutes. Next slide. Section 8.1. Bid opening, step-by-step, 1 of 2. Step 1. Confirm the deadline has passed, no further bids accepted from this moment forward. Step 2. Log any late arrivals, bidder name, representative, and exact time, per Section 54. 6. Then exclude them. Step 3. Check envelope sealing for every bid, unsealed, unmarked bids rejected outright, improperly sealed ones need bidder acknowledgement. Step 4. Open the first envelope, in public, for every bidder, regardless of the eventual award criterion, every first envelope opens together. Step 5. Read and record each bidder's submitted documents, cross-check against the itemized list for the applicable project type. Step 6. Determine the second envelope opening sequence, same day for LCRB. Held sealed pending technical scoring for MEARB, MARB. Next slide. Section 8.2. Bid opening, step by step, 2 of 2. Step 7. Read the bid prices allowed, where the criterion allows, this produces the abstract of bids as read. Step 8. Secure any unopened financial envelopes, for MEARB, MARB, until the specified later opening time. Step 9. Record the complete minutes, attendance, late bids, improperly sealed bids acknowledged, and bids as read. Step 10. Notify mailed-in bidders in writing, within 7 calendar days of the bid opening date. Step 11. Prepare the abstract of bids as read for public release, available upon written request and payment of a materials cost fee. Step 12. Proceed to preliminary examination, applying the non-discretionary pass or fail criterion to what was actually opened. Next slide. Section 9. Rejection, late bids, and sealing rules. The precise line between a bid that is rejected outright and one that may still be accepted with acknowledgement. Next slide. Section 9.1. Legal basis, the sealing rule, in full. Legal basis, IRR of RA number 12,009, Section 54. 9. Unsealed or unmarked bid envelopes, or in case of electronic bid submission, bidding documents not in compressed archive folders and are not password protected, shall be rejected. However, bid envelopes that are not properly sealed and marked or not properly compressed and password protected, as required in the bidding documents, shall be accepted, provided that the bidder or its duly authorized representative shall acknowledge such condition of the bid as submitted. The BAC shall assume no responsibility for misplaced or lost contents of the improperly sealed or marked bid or improperly compressed or password protected folder, or for its premature opening. Next slide. Section 9.2. 2 different defects, 2 different consequences. Unsealed and improperly sealed are not the same thing, and the law treats them completely differently. This is one of the most consequential distinctions in the entire bid opening framework. A bid envelope that is unsealed or unmarked entirely, or, for electronic submission, simply not placed in a compressed, password-protected folder at all, is rejected outright. No exceptions, no acknowledgement process available. A bid that is sealed and marked, or is compressed and password protected, but imperfectly so, some minor defect in how it was done, may still be accepted. But only if the bidder or its authorized representative formally acknowledges that condition at the time of submission or opening. Next slide. Section 9.3. The decision tree, applied. Condition of the bid, physical submission, electronic submission, consequence. Completely missing the required protection, no seal, no marking at all, not compressed, not password protected at all, rejected outright, no exception available. present but imperfect, sealed and marked, but not fully to specification, compressed and protected, but not fully to specification, accepted. Subject to the bidder's acknowledgement of the condition. Next slide. Section 9.4. Why the BAC's disclaimer of responsibility matters. The provision's closing sentence, that the BAC assumes no responsibility for misplaced or lost contents, or for premature opening, of an improperly sealed or protected bid, exists precisely because accepting such a bid inherently carries some risk that a fully compliant submission would not. The bidder, by submitting imperfectly and then acknowledging that condition, accepts that risk itself. This is why the acknowledgement step is not a mere formality. It is the legal mechanism that shifts the risk of an imperfect seal from the government back onto the bidder who created the imperfection in the first place. Next slide. Section 9. Observation. Common Audit Observation. Issue 8. Unsealed bid accepted without rejection. A bid envelope that was genuinely unsealed or unmarked, with no protective enclosure at all, was accepted and processed. Contrary to the outright rejection rule that applies to that specific defect. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 9. Next slide. Section 9. Observation. Common Audit Observation. Issue 9. Improperly sealed bid accepted without the bidder's acknowledgement. A bid that was imperfectly, but not entirely absent of sealing or marking was accepted and opened without first obtaining the bidder's or its representative's formal acknowledgement of that condition. Legal, regulatory basis, IRR of RA number 12,009, Section 54. 9. Next slide. Section 10. Electronic and scanned submission, special rules. How electronic bid submission changes what must be original at bid opening, and what may wait until post-qualification. Next slide. Section 10.1. Legal basis, scanned copies accepted at this stage. Legal basis, IRR of RA number 12,009, Section 59. 1. Receipt of the scanned copies of the first bid envelope with the required forms prescribed in this IRR, which are for online or electronic bid submission, shall be considered as compliant with the requirements of the said bid submission, subject to the submission of the original copies of the following: a. Bid securing declaration, or other forms of bid security, excluding cash, and b. Omnibus sworn statement. These forms shall be submitted by the bidder during the post-qualification stage. Next slide. Section 10.2. A detail many references miss entirely. 2 specific documents may be submitted as scans at opening, but their originals are only due at post-qualification, not before. This is a genuinely important, precise rule. For electronic bid submission, scanned copies of the entire first envelope, including the bid security and the Omnibus sworn statement, satisfy the requirements at the point of bid opening itself. The original hard copies of only these 2 specific documents, the bid security or bid securing declaration, and the Omnibus sworn statement, are not actually due until the post-qualification stage. Every other document in the envelope is expected in its scanned form at opening, with no separate original copy deadline attached by this specific provision. Next slide. Section 10.3. Legal basis, the consequence of not submitting the originals. Legal basis, IRR of RA number 12,009, Section 59. 1. The non-submission of these forms within the prescribed period shall render the bid submission as non-compliant and shall result in the post-disqualification of the bidder. Please take note of this specific rule when reviewing procurement documents. Next slide. Section 10.3. Why this matters for anyone tracking bidder compliance over time. A bidder who submits scanned copies electronically and is accepted at bid opening is not, at that point, finally and completely compliant. The obligation to produce the 2 originals carries forward into post-qualification, and failing that later obligation results specifically in post-disqualification. A distinct outcome from failing the preliminary examination itself. This means a bidder can validly pass bid opening and even preliminary examination on the strength of scanned documents. and still ultimately fail the process later if the two specific originals never materialize, a sequencing point worth tracking carefully across the whole procurement file. Next slide. Section 10.4. Legal basis, the same rule for the second envelope. Legal basis, IRR of RA number 12,009, Section 59. 2. Receipt of the scanned copies of the second bid envelope with the required forms such as the duly signed bid form, price schedules, or other forms prescribed in this IRR. For electronic or online bid submission, shall be considered as compliant with the requirements of the said bid submission. This is an important requirement to check during a compliance review. Next slide. Section 10.4. No special original copy carve-out for the second envelope. Notice that Section 59. 2 does not repeat the two-document original copy exception found in Section 59. 1 for the first envelope. Scanned copies of the second envelope, the bid form and price schedules, are simply treated as compliant on their own terms, without a parallel requirement to later produce physical originals of specific financial documents. Next slide. Section 10 Observation. Common Audit Observation. Issue 10. Original bid security or OS never produced after electronic submission. A bidder accepted through scanned electronic submission at bid opening failed to submit the original bid security or Omnibus sworn statement at post-qualification, yet was not post-disqualified as the rule requires. Legal, regulatory basis, IRR of RA number 12,009, Section 59. 1. Next slide. Section 11. Goods, infrastructure, and consulting services, compared. The same bid opening mechanics applied to 3 genuinely different document sets and risk profiles. Next slide. Section 11.1. The legal mechanics are shared, the content is not. Section 58's timing and manner of opening rules, and Section 54's 2 envelope structure, apply identically across all 3 project types. What genuinely differs is the itemized document list opened in each first envelope, discussed in full in Section 5 of this reference. And the specific risks a BAC should be alert to while opening and reading each type of bid. Next slide. Section 11.2. What the BAC should be watching for, by project type. Project type, particular points of attention at bid opening. Goods, whether the technical specifications compliance is evident on its face, whether SLCC and NFCC figures are present and internally consistent with the ABC, whether a foreign bidder has included the required reciprocity certification. Infrastructure projects, whether the PCAB license is present for JV bidders specifically, whether all 4 project requirements sub-items, organizational chart, personnel list, equipment list, and OS are present, whether the bill of quantities in the second envelope is complete for every pay item. Consulting services, whether the approach, work plan, and schedule is present, subject to the architectural design exception. Whether the list of key personnel matches the qualifications the terms of reference required. Whether shortlisting was properly completed before this bidder was even invited to submit. Next slide. Section 11.3. Infrastructure carries the longest, most itemized first envelope list. Comparing the 3 lists in Section 5 side by side, infrastructure projects carry the most granular requirement. The project requirements sub-item alone breaks into 4 further components: organizational chart, personnel, equipment, and the OS. This reflects the underlying reality that an infrastructure contractor's actual delivery capacity, personnel and equipment specifically, is far more variable and far more consequential to verify than for a straightforward goods supply. Next slide. Section 11.4. Consulting services carries the only structural timing dependency. Consulting services is the only one of the 3 project types where a bid opening cannot even be scheduled until an entirely separate, earlier process, shortlisting under Section 53, has concluded. This means the bid opening for a consulting services engagement is opening the bids of a pre-vetted, pre-shortlisted pool, not an open field of respondents to the original request for expression of interest. Next slide. Section 13. Applicability by mode of procurement. Which modes actually generate a bid opening in the Section 58 sense, and which never do. Next slide. Section 13.1. Sealed bid modes versus direct engagement modes. Bid opening, as Section 58 defines it, presumes the existence of sealed, competitively submitted bids. Competitive bidding, competitive dialogue, limited source bidding, and unsolicited offer with bid matching all generate exactly that. And their resulting submissions are opened under this framework. Small value procurement, direct contracting, and most negotiated procurement grounds instead generate quotations sent directly by a small number of identified suppliers. Contractors, or consultants, in response to an RFQ or RFP. These are received and evaluated, but not through the formal, public, two-envelope bid opening ceremony this reference describes. Next slide. Section 13.2. Applicability, mode by mode. Mode of procurement, formal bid opening, Section 58, applies. Competitive bidding, yes, in full. Competitive dialogue, yes, in full. Limited source bidding, yes, in full. Unsolicited offer with bid matching, yes, in full. Small value procurement, no. Quotations are received and reviewed as they arrive, not through a formal opening ceremony. Direct contracting, no. A single supplier's quotation is simply received and reviewed. Most negotiated procurement grounds, no. Offers are received directly from identified parties. Next slide. Section 13.3. Small value procurement still has its own, lighter receipt discipline. Even though small value procurement does not use the formal Section 58 ceremony, it is not entirely undisciplined. Section 34. 3c. Still requires that at least one compliant quotation be received before the BAC may proceed with evaluation and basic integrity practices, such as time-stamping receipt of each quotation, remain good practice even without a formal public opening event. Next slide. Section 13. Observation. Common audit observation. Issue 15. Formal bid opening procedures misapplied to a non-competitive mode. A BAC either conducted an unnecessary, formal public bid opening ceremony for a small value procurement or direct contracting transaction, or, conversely, treated a genuine competitive bidding submission informally, without the public, recorded process Section 58 requires. Legal, regulatory basis, IRR of RA number 12,009, Section 58, Section 26. 1. Next slide. Section 14. Virtual and electronic conduct. Bid opening's own explicit rule on conducting this specific stage electronically. Next slide. Section 14.1. Legal basis, the specific rule for bid opening. Legal basis, IRR of RA number 12,009, Section 58. For electronic bid submission, if applicable. The passwords for accessing the bidding documents will be disclosed by the bidders only during the actual bid opening, which may be done in person or through video conferencing, webcasting, or similar technology. Government personnel should follow this provision closely to avoid procedural defects. Next slide. Section 14.2. The single most important word in this rule is only. A password disclosed even slightly early defeats the entire purpose of the sealed bid system. This rule does not merely permit electronic bid opening, it insists that the password for an electronically submitted bid be disclosed only during the actual bid opening, whether that opening happens in person or through video conferencing. A bidder or a BAC member who discloses, or receives, a password before the scheduled opening moment has effectively pre-opened a sealed bid. Precisely the integrity breach the physical two-envelope sealing requirement was designed to prevent. Virtual bid opening does not relax this timing requirement. It simply changes the mechanism by which the same discipline is enforced. Next slide. Section 14.3. How this interacts with the scanned document rules in Section 10. The password timing rule and the scanned copy acceptance rules discussed earlier in this reference work together. A bidder may submit scanned documents electronically well before the deadline, but the password that actually unlocks those files is withheld by the bidder itself until the moment of opening, exactly mirroring how a physical sealed envelope is submitted early but not opened until the scheduled time. Next slide. Section 14.4. Conducting a virtual or hybrid bid opening, step by step. Step 1. Confirm genuine technology capability, video conferencing or webcasting capability that actually exists, not merely an intention to use it. Step 2. Confirm the schedule time, date, and place remain as specified. Even a virtual opening must occur at the time fixed in the bidding documents. Step 3. Withhold all passwords until that exact moment, no early disclosure, by either the bidder or any back member, under any circumstance. Step 4. Open and read bids in the same sequence as an in-person opening, LCRB same day, or MEARB, MARB staggered, exactly as Section 58 requires. Step 5. Record the session, a recording or webcast log, alongside the same written minutes an in-person opening would require. Step 6. Prepare and release the abstract of bids as read, exactly as required for an in-person opening, upon written request and fee payment. Next slide. Section 14.5. Virtual bid opening checklist. Procuring entity genuinely possesses video conferencing, webcasting, or similar technology capability. Time, date, and place remain exactly as specified in the bidding documents, notwithstanding the virtual format. No password for any electronically submitted bid disclosed before the actual, scheduled opening moment. Correct opening sequence followed for the applicable award criterion, LCRB same day, or MEARB, MARB staggered. Recording or webcast log retained alongside the written minutes. Abstract of bids as read prepared and available on the same terms as an in-person opening. Next slide. Section 14 Observation. Common Audit Observation. Issue 16. Electronic bid password disclosed before the scheduled opening. A bidder disclosed, or a back member received, the password for an electronically submitted bid before the actual, scheduled moment of bid opening, compromising the integrity of the sealed bid system regardless of the format used. Legal, regulatory basis, IRR of RA number 12009, Section 58. Next slide. Section 14 Observation. Common Audit Observation. Issue 17. No recording retained for a virtual or hybrid bid opening. A virtually or hybrid conducted bid opening left no recording or webcast log on file, only written minutes, leaving no independently verifiable record that the electronic portion of the session actually occurred as claimed. Legal, regulatory basis, IRR of RA number 12009, Section 58. Next slide. Section 15. The top 20 reasons a bidder failed to pass. Drawn directly from the specific documentary and procedural rules covered throughout this reference. Next slide. Section 15.1. Why this list sits here, at bid opening, and not only at evaluation. Many of these 20 reasons are actually discovered right here, at bid opening itself and the preliminary examination that follows immediately after. Since the non-discretionary pass or fail check under Section 59. 1 is applied to precisely the documents this reference has itemized in full. This list is deliberately organized to track the actual sequence of this reference, submission and sealing defects first. Then the itemized document omissions specific to each project type, then the more substantive pricing and compliance failures that follow. Next slide. Section 15.2. Reasons 1 to 5, submission and sealing defects. Reason, basis. 1. Bid submitted after the deadline, Section 54. 6. 2. Envelope unsealed or unmarked entirely, or, electronically, not compressed, password protected at all, Section 54. 9. 3. Bid form not typewritten or written in ink, or left unsigned, Section 54. 8. 4. Improperly sealed bid accepted without the bidder's required acknowledgement, Section 54. 9. 5. Original bid security or OS never produced at post-qualification after electronic submission, Section 59. 1. Next slide. Section 15.3. Reasons 6 to 12. Missing or deficient first envelope documents. Reason, basis. 6. Missing or expired Phil Gepps Certificate of Registration, Platinum Membership, Section 54. 2. 1B, 1C, 7. 7. Missing or improperly executed Omnibus Sworn Statement, Section 54. 3. 8. Statement of SLCC missing, insufficient, or not properly supported, Section 54. 2. 3B, 4. 9. NFCC below the ABC, or missing, insufficient computation, Section 54. 2. 4B, 5. 10. Missing bid security, or wrong form, amount, or validity period, Section 54. 2. 6B, 7C, 1. 11. Missing PCAB license for an infrastructure joint venture bidder, Section 54. 2B, 2. 12. Missing JVA or notarized statement of joint venture intent, where applicable, Section 54. 2. 5B, 6. Next slide. Section 15.4. Reasons 13 to 17. Project type specific deficiencies. Reason, basis. 13. Missing or incomplete technical specifications compliance, goods, Section 54. 2. 7. 14. Missing project requirements sub-item, org chart, personnel list, or equipment list, infrastructure, Section 54. 2B, 8. 15. Missing approach, work plan, and schedule, consulting services, Section 54. 2C, 4. 16. Missing list of key personnel with qualifications, consulting services, Section 54. 2C, 5. 17. Missing foreign reciprocity certification for a foreign bidder claiming eligibility, goods, Section 54. 2. 9. Next slide. Section 15.5. Reasons 18 to 20. Pricing and responsiveness failures. Reason, basis. 18. Total bid price, after correction, exceeds the ABC, Section 59. 2. Section 61. 2. 4. 19. Bid found non-responsive for missing an item specifically required in the bill of quantities or price schedule, Section 59. 2. 20. Statement of all ongoing government and private contracts missing or incomplete, Section 54. 2. 2B, 3. Next slide. Section 15.6. The pattern behind the 20. Look closely at the sequence. Reasons 1 through 5 are almost entirely mechanical, about how and when the bid physically arrived, not about its actual content. Reasons 6 through 17 are document completeness failures, each traceable to one specific, itemized requirement from Section 5 of this reference. Reasons 18 through 20 are substantive, about whether the bid's price and scope actually responds to what was asked for. A BAC that systematically checks every bid against this exact sequence, mechanical defects first, then document completeness by project type, then substance, will catch the overwhelming majority of the reasons bids actually fail, in the order those reasons are most efficiently checked. Next slide. Section 15. Observation. Common audit observation. Issue 18. Top 20 reasons not used as a systematic pre-check before rating a bid. A bid was rated passed at bid opening or the immediately following preliminary examination without evidence that the BAC systematically checked it against the recurring. Documented failure patterns common to this stage. Legal, regulatory basis, IRR of RA number 12,009, Section 59. 1. Next slide. Section 16. Documents checklist. Audit observations, and closing. Everything that should exist on file to prove bid opening was conducted correctly, and the full pattern behind every observation in this reference. Next slide. Section 16.1. The Master Documents Checklist. For every bidder, 2 properly sealed and marked envelopes, submitted simultaneously, received before the deadline, per Section 54. 1 and 54. 6. First envelope, goods. Phil Gepps Platinum, Statement of Ongoing Contracts, SLCC Statement, NFCC or Line of Credit, JVA if applicable, Bid Security, Technical Specifications. Omnibus Sworn Statement, and, where relevant, a Foreign Reciprocity Certification. First envelope, Infrastructure. Phil Gepps Platinum, PCAB License, JV Cases, Statement of Ongoing Contracts, SLCC Statement, NFCC, JVA if applicable, Bid Security. And the 4-part Project Requirements Bundle, Organizational Chart, Personnel List, Equipment List, and Omnibus Sworn Statement. First envelope, Consulting Services. Bid Security, Organizational Chart, List of completed, ongoing projects, approach, work plan, schedule, list of key personnel. Omnibus Sworn Statement, and Phil Gepps Platinum. Second envelope, all project types. Bid form, price schedule, and, for infrastructure, the completed bill of quantities. The BAC's checklist of required documents, prepared in advance and used as the actual pass-fail instrument at the opening and the immediately following preliminary examination. The abstract of bids as read, and the minutes of the bid opening itself. For virtual or electronic sessions, proof of technology capability, and a timestamp record of password disclosure timing. Next slide. Section 16.2. The 18 numbered observations from this reference, consolidated. 1. Second envelope opened prematurely under MEARB, MARB. 2 to 3. Postponement or public access failures. 4 to 5. Documents opened did not match the required list, or the OS was incomplete. 6 to 7. BAC failed to check or record required items properly. 8 to 9. Improper rejection or acceptance of sealed, unsealed bids, or late bids processed. 10. Electronic, scanned submission handled incorrectly. 11. Equipment, tools bids for a force account project opened informally. 12. A contractor was used for work labeled by administration. 13. PAC your arrangement showed bid opening characteristics it should never have. 14. PAC your contract exceeded the 500,000 peso per group cap. 15. Formal bid opening procedures misapplied to a non-competitive mode. 16 to 17. Virtual conduct mishandled, password disclosed early, or no recording retained. 18. The top 20 list not used as a systematic check. Next slide. Section 16.3. The single idea behind every observation in this reference. Bid opening looks, on its surface, like a simple mechanical act. Unseal the envelopes, read the prices, write the minutes. Nearly every observation in this reference shows that the substance underneath that simple act is not simple at all, a specific. Itemized document list that differs by project type, a sequencing rule that depends on the award criterion, and a battery of sealing, timing, and disclosure rules that all exist to protect the same underlying value, that no bidder is ever treated differently from any other. A BAC that opens bids against the correct, itemized checklist for the actual project type, follows the correct opening sequence for the actual award criterion, and documents every step precisely as this reference describes, is very difficult to fault on audit, because it has done exactly what sections 54 and 58 actually require. Next slide. End of guide. Bid opening is where every earlier safeguard is finally, publicly tested. Whether the project is goods, infrastructure, or consulting services, whether the award criterion is price alone or price and quality together, and whether the opening happens in a room or through a screen, the same discipline governs. Open only what has arrived on time and properly sealed. Check it against the exact list the law requires for that project type, and record all of it, so the record itself proves the opening was done correctly.